went into family law, A, because so many people asked me to do their divorces and to do family law. B, because I've been divorced before. So I actually had personal experience. I've been on the other side of the desk. As the number of divorces increase, the counties are requiring people now to attend mediation. And what they do is they go to a mediator. And again, they try, hopefully that mediator will help them to try and resolve their differences. If not, then they go to trial. In addition to mediation, a number of counties are now instituting what is called early neutral evaluation. And what that is the parties bring whatever it is they are disputing, their dispute, their argument, to a person such as me, or anybody else that's had training in early neutral evaluation. And we give the parties our opinion as to what we think the trial court will do. The attorney knows what to ask for. The attorney also knows what the magic language is in divorce law. And there is magic language. There are certain things that, by the words that are used, either give you rights or take rights away. And you're not going to know that. And I often tell my clients that the first thing they teach us in law school is to say, it depends. And everything is real fact determinative. And in this case, again, it's fact determinative. You say, what happens to my children? Well, are they living with you? Has your husband moved out? Is your husband still in the home? Does your husband want you to leave and keep the children? If you're unable to agree on where the children live and who stays with them or who doesn't stay with them, you can ask the court to make a decision on a short-term basis. It's called a temporary motion, and it gives you what's called temporary relief. All that is a short-term order that is in effect until your actual divorce goes through. The trend in family law is to encourage the parents to decide on their own. If they are unable to decide, however, they first attempt to go to mediation, or hopefully they do. And hopefully a mediator will be able to talk to the parents and uncover a lot of times what the real issues and fears are. If that doesn't work, then a custody evaluation is started. So what happens is you hire a custody evaluator. There's no specific licensing or anything for a custody evaluator. Anybody can hang a shingle out that says custody evaluator. So most people have to trust their attorneys to select the custody evaluator. If the child hasn't graduated from high school, you can obtain child support up until that child is age 20, so long as that child is still attending high school. You go down to the county that you live in, Department of Human Services, and you apply for automatic income withholding. And you fill out, basically you fill out forms, you pay them a certain amount of money, and it's not a whole lot, and they will institute automatic income withholding, meaning they will contact the obligor's employer, direct them to withhold whatever the appropriate amount is, and then they send you the check. Spousal maintenance is alimony. It's, again, up to the district court's discretion as to if they give you spousal maintenance, and if so, how much. It's a two-step process. The first process is, do you need, do you need the money? Do you need spousal maintenance? Well, a lot of times, yeah, that part's real easy. The second part of that test, though, is the other party able to pay it? So if you haven't worked and your husband's laid off, well, there's not really a lot of money to pay alimony with. But you pass the first test. In other words, do you need the money to live? and your husband has the ability to pay, then again, you're looking at the discretion of the trial court. The reason you want a will is you want to leave your property to someone or some persons other than what the Minnesota will is. The Minnesota will is the intestate statute, intestate succession statute. And what that is that says that when you die, if you don't have a will, these people, a variety of different people, get your property. Powers of attorney apply when you are living. The reason you would have one is, again, if I'm unable to speak for myself. You still own property, you still probably want to sell your house, you still probably have checks coming in that need to be signed. It allows another person to step into your shoes legally and manage, sell, or obtain your property.